This video continues the lectures for my professional responsibility course, and we're going to be talking about personal conflicts of interest under Model Rule 1.7 in this video. In other words, instead of talking about conflicts between clients, 1.7 A2 also applies to conflicts that the client may have with, or between the lawyer's vested interest, personal vested interest, and the client. So we're going to talk about personal conflicts of interest. In comment 10 to Rule 1.7, it says that the lawyer's own interest should not be permitted to have an adverse effect on the representation of a client. I want to kind of insert something here. The model rules are primarily what we're studying in class and are what's mostly tested on the MPRE. You should be aware that there's also a restatement about the law governing lawyers, and it's the restatement third of the law governing lawyers. Many of the provisions track the model rules, sometimes verbatim, and so it would be duplicative to kind of try to teach both. We turn to the restatement when there's an ethical issue like attorney-client privilege or legal malpractice for which we don't have model rule sections. This brings up, though, an issue where you should be aware that the restatement of the law governing lawyers puts a lot of emphasis on the fiduciary duties of a lawyer to the client. And when we talk about fiduciary duties in law, that is a term of art that means the party with the fiduciary duty has a legal duty to put the other person's interests before their own, not even on the same level, before their own. In other words, the lawyer must subordinate his personal interests to those of the client. And that's somewhat reflected in comment 10. The model rule comments do not use as strong language, a fiduciary duty language as the restatement. But you should be aware that if you are in a malpractice, a legal malpractice action, the court may actually look to the restatement or follow the restatement for the duty of care. Okay, so the comment 10 gives us a few examples that are really important to talk about, and because these specific examples are very likely to get turned into test questions on your MPRE. It's so easy to make them into multiple choice questions. So, for example, if the probity of a lawyer's own conduct in a transaction is in serious question, it may be difficult or impossible for the lawyer to give a client detached advice. So in other words, you did previous legal work, and that is what is now being the subject of the dispute. You shouldn't be representing someone if you're simultaneously going to have to kind of defend your prior legal work. I'll give you a quick example. Let's say you represent a lot of commercial or residential landlords, landlords who own apartment buildings, and at some point you draft a lease that for one of your clients that the client can use with their tenants who are renting. This would also work if it's a commercial property, like you have a mall, a shopping mall that rents units to stores. And so you forget all about it. And 10 years later, a client comes to you, and a prospective client, and it's a tenant, and they're wanting to get out of a lease or challenge a lease. And they show you their lease. Now, their landlord, they say, is someone you've never heard of and you've never represented. But when you start looking at the lease, you realize it's your lease that you drafted, that now you are going to have to challenge. You're going to challenge either the validity of it, or you're going to say the provisions are so ambiguous that the tenant can get out of it, and so forth. Now, how did this happen? Why does someone, an opposing party you've never heard of, why are they using your lease? Well, maybe your previous client sold out, right? Someone bought their apartment building, sold their apartment building. They keep the tenants there and often just keep them under the same lease agreements. And so it's actually pretty common. Also, maybe one landlord had a lawyer draft their lease for them and then had friends that were landlords that owned apartment buildings and shared the lease that he uses, that you drafted, with others. So in any case, though, the new client wants you to challenge a lease or a contract that you drafted. That's going to go to the probity of your own conduct as a lawyer. What are you going to do? Go into court and say, what kind of idiot would have drafted a lease like this? You could drive a truck through the holes in this thing. And the answer is you did it. So of course you have a personal conflict of interest because the case is going to turn on your own conduct. Similarly, when a lawyer has discussions concerning possible employment with an opponent of the lawyer's client or with a law firm representing the opponent, such discussions could materially limit the lawyer's representation of the client. So at the end of, you do a deposition, you're a new associate after you've graduated from law school and passed the bar, and you get sent to do a deposition. And at the end of the deposition, the opposing counsel comes over and says, I want to tell you something. That was amazing. You're amazing. You're one of the rising stars in our legal community. I've never seen a lawyer do such a great job with a deposition. And so, you know what? My firm is always looking to hire, superstar lawyers and rising stars and talented people. So here's my card. You have my information. Send us your resume because we're hiring and we could probably pay you more than what you are looking for. And you're all excited, you run back to your office, you send in your resume and so forth. Well, you are this is kind of a cheap trick, an old trick that people use to mess with the minds of newer lawyers or recent law grads, to butter you up and then make you do something that's going to come back to haunt you later. And so, no, you shouldn't be negotiating for employment with opposing counsel's firm when they're the opposing counsel in a case that you're working on, because again, maybe you're going to worry about offending them, or you don't want to beat them too badly, or they're going to offer to settle and you're going to say, well, that seems reasonable, or something like that, because you have a job interview with that person coming up. So that's kind of off limits. Here's another example. A lawyer may not allow related business interests to affect representation. So, for example, by referring clients to an enterprise in which the lawyer has an undisclosed financial interest. And so your clients, let's say you've invested some of your disposable income in a friend's business who opens a medical testing center or a chiropractic practice or something like that, and you send your clients there. You have a duty to disclose to those clients that you are invested. Okay, next. Lawyers representing different clients in the same matter or in substantially related matters are closely related by blood or marriage. There may be a significant risk that client confidences will be revealed, and the lawyer's family relationships will interfere with both loyalty and independent professional judgment. And so obviously, I know they do this on TV lawyer shows all the time where they have the husband and wife are opposing counsel in a case, or boyfriend, girlfriend are opposing counsel in a case. And you can't do that in real life. That creates a conflict of interest. At a minimum, you would need to disclose that to the client. Both of you would need to disclose that. So if you're a criminal defense lawyer and you're married to a prosecutor and the two of you have a case against each other, that's a conflict of interest that would necessitate at least getting informed consent confirmed in writing, and probably you shouldn't do it anyways, because we're worried about two things. We're worried about the person clouding your judgment. We're worried that you will leak confidential information because you live with this person. People disclose a lot of things, or have their guard down with the people that they live with, and so forth. So each client is entitled at least to know of the existence and implications of the relationship between the lawyers before the lawyer agrees to undertake the representation. So a lawyer related to another lawyer, like as a parent or child, there's a number of people who go to law school who are the children of lawyers themselves. And so at some point you could have a case where your mom or dad or your kid, I have grown children, and my son is a lawyer now, for example, so in theory, if you were practicing, one of your own grown children could be a lawyer on the other side. Sibling or spouse ordinarily may not represent a client in a matter that where the lawyer is representing another party, unless each client gives informed consent. And maybe they will, but still it's probably a bad idea. Okay, we have a rule, and we actually have two rules. You are not allowed to have sex with your clients. We had to make a rule. So a lawyer is prohibited from engaging in sexual relationships with a client unless the sexual relationship predates the formation of the lawyer-client relationship. Now, this appears two places in the model rule, so we're going to talk about it again. It's a standalone rule in 1.8J, but that's a pretty new addition last decade or so to the model rules. And so it's also in the comments to 1.7. So even states that haven't adopted the new rule 1.8J, which basically says exactly what this comment says, all of those jurisdictions have 1.7, and so this comment would still be persuasive authority. Now, please note, if you have a sexual relationship already with someone, so you have it could be your spouse, or it could be a boyfriend or girlfriend, and then that person says, hey, I need a lawyer, will you do my case? Then you can, because that predates the formation of the client-lawyer relationship. But it's a conflict of interest if you are sleeping with your client. And again, I don't care what they do on the Hollywood lawyer shows, you can't do this because it affects your objectivity. Now, and notice, even if your state hasn't adopted Rule 1.8J, which is when we're going to come across the no sex with clients rule again, courts have no trouble applying 1.7 or its model code predecessor to lawyer-client sexual relationships. And I give you some citations here. You don't need to know them, but if you're interested in looking up cases, they're not hard to find. There's one from the Fifth Circuit in 2001, one from Louisiana in 2008, one from Maryland in 2009. I like this one from South Carolina. This is sex with the client's wife is a per se violation of Rule 1.7. So you're also not supposed to sleep with your client's wife. And now keep this in mind that that this is going to create all sorts of problems, right? A lot of these relationships, these sort of flings that people have, end badly, and so this is also likely to turn into not only a failed relationship, but a failed representation. Okay, moving on from that, there are a couple ABA ethics opinions about personal conflicts of interest that relate to bail, one from 2002 and one from 2004. And they don't really give us a bright line rule. And so the idea is you're a criminal defense lawyer and your client gets arrested. Can you post bail out of your own money for your client to get your client out of jail? And the earlier one, which is the bottom one here, is from 2002, and this discusses the propriety. I'm sorry, that's about security interests. 2004, we'll talk about the top one, is advancing bail on behalf of an accused client may pose a conflict if the amount of bail is material to the lawyer. And so what we're talking about here is, let's say bail it's a low bail amount. It's $5,000 or $10,000. Well, if you are barely getting by, you're still living, sleeping on a friend's couch and skipping meals and things like that because you are flat broke and trying to get your law practice started, $5,000 is a lot for you. And so, yes, you now have a little too much skin in the game as the lawyer, let's say. On the other hand, if you are a multimillionaire or billionaire lawyer and you post a $5,000 bond or bail for your client, that may be throwaway money for you. And so that's what the opinion basically says, is it kind of depends on the amount and how much that is for the lawyer. How much skin in the game does that really give the lawyer? And that's going to depend largely on how much is that money worth to you. So what the ABA opinion basically says is it could, in some circumstances, create a conflict of interest, and in other circumstances it wouldn't. Now let's talk about the second one here, which talks about taking security interest in the client's property as a guarantee of fees. And so this is, if you've taken secured transactions, you may be familiar with with this type of situation with business equipment and so on and security interests. And so the client can't pay your fees right now, but they promise to get you the money someday. And so you take a security interest in some of their property. It could be real estate, it could be business equipment, it could be a car or something like that, and kind of have a lien on that. To do this, again, the opinion doesn't, we wish it would draw a bright line for us, and it doesn't. Instead, it says, as you might expect, this can create a conflict of interest depending on, again, how much skin in the game you have as a lawyer, and a number of other factors like that. Overall, though, you should be aware that we have these sort of subtle situations that are pretty common, actually, that arise, that then give rise to questions of the lawyer's objectivity. Does the lawyer have too much personal stake in what's going on? And it's going to affect how they advise the client, how they treat the client, how hard they work on the client's case, and so forth, because now the lawyer has a personal interest in part of the outcome of the case, and that can be a problem. Okay, so that concludes this part of our lecture.